What's up, everybody? It's Peter Tragos, and today we're going to go case by case, talk through a few things together, and then at the end, do a Q&A as usual, Friday at 4 o'clock. That's when we get together and we get to talk as a channel together. I get to get your input as potential jurors. You get to get my input and my reaction as an attorney. The cases we're going to focus on today are Curtis Reeves. The closing arguments just finished. I believe they're reading the jury instructions right now to the jury. We're going to talk about Ghislaine Maxwell. Unprecedented things happening there with the juror that is going to get questioned because his truthfulness is being called into question based on the way he answered questions on the jury questionnaire. We're going to look at that questionnaire together, and you can let me know if you think he was not truthful. And then the last case we're going to talk about are the three law enforcement officers that were charged and convicted of federal crimes of violating George Floyd's civil rights, not rendering aid. We're going to talk about what they could potentially be sentenced with, and how that is also unprecedented, as it is the first time ever, I believe, that officers have been charged federally with this crime and convicted by a jury. So we'll talk through these three cases for the most part. And I think as I finish kind of talking about one case, we'll go ahead and answer some questions on that case. Then I'll move to the second one, answer questions. Then I'll move to the third one, answer questions. And then at the end, it'll be totally open to answer all of your questions as usual. That's one of my favorite parts of the show. Cordoba, you haven't missed anything. We are just getting started. So because Curtis Reeves is fresh on the brain and it's happening right now in Pasco County, we're going to talk a little bit about closing arguments, and we'll talk a little bit about the case in whole. So to me, the closings seemed incredibly long. This trial has seemed a lot longer than it needed to be. I think a lot of the expert testimony was way too drawn out. It was a little slow, especially the medical testimony. I think they could prove that he's getting older and he is slowing down, and he's more susceptible to damage in a fight. I think they could have done that much quicker. And then the video evidence I thought was brutally slow and boring, personally. But the state's closing, they started out by trying to dismantle the defense by talking about what shiny objects the defense were trying to basically trick the jury with. There were some mischaracterizations of evidence and argument, in my opinion, in both closings. I didn't think the state's was incredibly effective. I would have taken more time talking through self-defense and how they disproved self-defense, because they have to do that beyond a reasonable doubt. But I don't think the defense did a great job of saying how they didn't prove that. I don't think either closing really changed any jurors' minds. When we pick a jury, we categorize jurors as leaders and followers a lot of times as we're picking them, which jury members may have jobs or life experience or things that have happened that make us think that they would be leaders, which mean if they agree with us, they are more likely to be able to bring other jurors with them. Or if they're followers and they agree with us, we need them to be strong in agreeing with us. But if they agree with the prosecution at this point, we would be, they would potentially be able to be convinced by some leaders that may agree with us. So it's hard to know which jurors are kind of with you as the trial goes on. But I don't think that either closing really was going to change a lot of jurors' minds. I thought the defense had some really good points, some that I had not really thought of. And again, just for those of you that may be frustrated that I haven't watched every second of this trial and I don't stream the trial live on my channel the entire time, that is not this channel. There are a lot of channels that do that. A lot of them are really good. The LawTube people that do that do a great job. And I have popped onto some of their shows and would be happy to pop onto their shows and talk about it. It's just not feasible for me and where I am and what I do in my career, because I practice law every single day. I know I feel like I say that every video, but it seems like every video people are coming at me like, oh, you didn't see this witness or you don't watch the whole trial. How can you have an opinion? It's actually very easy to have an opinion because I try cases exactly like this against these prosecutors in front of these judges and with a lot of these expert witnesses, especially in this case. So I have some insight into how it's done and what they're thinking and what they do. So it's fun to talk about. And it's fun to get you all involved in the conversation as well. So it's never going to be a channel where I sit here and stream trials all day. But I thought the defense made some really good points where they talked about how when Mr. Reeves got back from complaining to the manager, he grabbed the popcorn from his wife's hand and then he sat down. Does that sound like a man that's getting ready for a fight or that wants to instigate trouble with a guy that's just been cursing at him? To me, no way. That does not indicate to me a guy that wants to start a fight. Okay? Now, does that absolve him of all guilt? No. But I think it was a really good point. And I think the strongest evidence the defense has is, I guess we'll call it Mr. Reeves' story, even though he is not sure that this happened, that Olson, the victim, the alleged victim, threw his cell phone and it hit Mr. Reeves in the head, in the eye, whatever that is. And that is a battery on an elderly person, which is a felony for which you can respond with deadly force potentially. Now, none of us are going to be happy about this. None of us want people getting shot in movie theaters. A lot of us may not want guns to be able to come into movie theaters. And that's why they sued. That's one of the things that the Olsons, when they sued the movie theater, they said, you have to have something in place that actually doesn't let people bring guns in. There is no actual security. You have a sign, but you need to do something to stop people from actually bringing guns in. And that's what one of the pieces of their civil suit was, which I agree with. But while we all don't want that, none of us really want people to get shot and die anyways, whether they mouth off or throw popcorn or what. But if the jury believes the events as if they believe the events as the defense explains them, where first a cell phone, so the standing up and the cursing and getting in his face, then a cell phone is thrown and hits you in the face. Then popcorn is taken from your hand and you're touched when he grabs it and he throws that at you. And then his fist is clenched like he's coming at you to punch you when the residue or whatever was on his hand but not on his fingers, so that the expert explained that it was a clenched fist. I thought that was all effective testimony. That, to me, gives the jury absolutely something to hold on to with self-defense, and I don't believe the state has proven that beyond a reasonable doubt that that is not the case. Which is why one of the major differences I would have done if I was the state attorney on this case, in opening and throughout the case, they said there wasn't a mark on him except for the, red mark on his face where his face got hit or whatever. They kind of gave a little bit to the defense. I would have stuck to no injuries, no damage done to him, nothing happened to him. He is trying to come up with a reason that he had some discoloration of his skin, but there's no actual evidence or testimony that he was hit with anything. He didn't tell him the day of, he didn't tell him here, he didn't tell him there. Now he's telling you, and he's coming up with that at trial to try to create some reason for him shooting Mr. Olson, which was not true. I thought the argument that the defendant said he put his hand up and was touching Mr. Olson's chest. This is probably before Reeves knew there was a video. That argument from the state saying, yeah, that would have made sense if Olson was barreling over him and he had to put his hand on his chest to hold Olson back. Then it makes sense you're in fear for your life and you have to shoot. But that's not the case. We all see in the video, he is not holding Mr. Olson back with his left hand. Those are some things I really would dig deep in if I am the state in this case. I would never have admitted that there was any injury. And it seemed like they kind of quibbled a little bit and almost admitted that there was an injury to his eye. And I don't think there was really any testimony besides Mr. Reeves saying he may have thrown the cell phone. Here's the other thing, and you guys track with me here and let me know in the chat. How could the cell phone have ever ended up next to Curtis Reeves' feet? Well, if Olson was holding the cell phone in his right hand and he got shot in the chest, if he was leaning over the seat, it's very plausible the cell phone dropped out of his hand and hit the ground, right? I mean, there's no testimony of that, but you can argue that from the facts in this case, that that's how the cell phone got on the ground. If the guy was leaning over the seat and he gets shot, he lets go of his cell phone. And I think that's something a jury can believe and can easily kind of walk towards if they track through that. So, I mean, that's kind of some things where, I really don't know how this is going to come out. Let's get in the chat here. Let's do because there's lesser included, there's the second degree murder and the manslaughter. Let's just put either, you can put GM2. This is super complicated. I don't know why I'm doing this, but for murder 2. So GM2, if you think he's guilty of that. G-mans, if you think he's guilty of manslaughter. And then NG, if you think he's just not guilty. Now, we're not going to talk about the aggravated battery to the wife because that pretty much just tracks with whether or not you think he's guilty or not guilty for what he did to Chad Olson. Everybody seems to agree with that. So, yeah, let me know. Let me know if what you think, guilty, which charge, or not guilty in the chat. And I'm going to kind of go through my thought process here. So if I had to bet or say which way I'm leaning, I still think that a jury in Pasco County of normal people are going to say and think, we can't have people shooting people in movie theaters. We can't have people shooting people over being cursed at or even throwing popcorn at them. So, I still am kind of leaning that the jury is going to come back with a guilty verdict, but I will say, after listening to this trial, I think the defense has shown that there's enough reasonable doubt here. Now, again, we've talked a lot about the cops and the shoddy job they did. I was shocked at how much the prosecution agreed and admitted what a horrible investigation this was, but I actually think it was a good idea because this investigation was not well done by these police officers. Not at all. But I do think that the defense created enough discussion that it wasn't over popcorn because he wouldn't have even had enough time to react in 0.7 seconds from when the popcorn was thrown to when the shot was done. And that if this series of events happened where he was throwing multiple objects at an old man sitting down in a vulnerable position, and if he was coming with a fist, then absolutely force was justified. If that is true, okay, and I'm not on the jury, so I don't have to decide that, but I'm just going to tell you, if I believe Curtis Reeves, if I believe that there were multiple things thrown at him, I think it's not guilty, personally. But if I watch that video, it looks to me like Olson throws the popcorn and then goes back, and that's what he shot. So now, as a juror, I've got to deal with that video. And do I think that video shows guilt? That's what you've got to do as a jury. And in my opinion, the defense did enough to where I am not confident myself that the state has met its burden. And I know people think that's a cop-out and that's horrible, but that is our criminal justice system. And it's better that some guilty people go free than one innocent person get convicted and be imprisoned. So that's kind of where I'm leaning personally. If I was a juror, I'd never be picked to be a juror on this case. So my opinion doesn't really matter. I want to hear from you. And if I look in the chat here, yeah, you know what? It would have just been a better idea to say murder 2, manslaughter, or not guilty. But you guys figure that out on your own. All right. So I have 1, 2, 3, 4, a couple of not guilties. And then I've got 1, 2, 3, 4, 4-ish manslaughters, and then 1, 2, 3, 4, 5. Kind of the majority is guilty murder 2. So definitely majority would be saying guilty of something. And of those, it seems to be more guilty of murder 2, which is the evil intent, depraved heart, than just the manslaughter charge. So that's kind of where our chat is leaning. It's only 100 people and not a ton of you have voted guilty or not guilty. If you're voting guilty or not guilty, go ahead and hit the like button at the same time if you haven't already, so we can just get all the votes out of the way now. And we can keep moving forward. But to me, this is a really interesting case. Media narrative seemed like a slam dunk for the prosecution. I think the defense lawyers have done a really great job throughout this case. And I think that So the defense closing was long. Okay, we can all agree with that. But it's really hard for a defense attorney to not uncover every stone, especially in this case where you feel like you have a lot to argue and a lot to go through. You want to talk about his age. You want to talk about his decorated past. You want to talk about his infirmities. You want to talk about the facts of the case, obviously. You want to talk about the self-defense instructions. You want to talk about the shoddy police work. So I get why he felt like he had a lot to talk about. I definitely think it could have been. I like to keep my closings under an hour in just about every case. If I'm going to play video and show pictures and stuff, I can break it up. But an hour to an hour and a half is, about as much as I want to. And some judges won't let you go too long, especially in civil cases, which is mostly what I do, although I've tried more criminal cases than civil cases. But in criminal cases, you're given a little more leeway. So, so that's kind of why I think the defense went a little bit long. But I do think that there is enough in this case to create reasonable doubt. In my mind, it seems like the chat does not agree. And there's more guilty votes coming in now by a wide margin. All right. Okay, so that's kind of where we are on Reeves. We're not going to get a verdict till next week. So now is the time to put your questions on Curtis Reeves in the chat. I'm going to scroll through, see if there are any questions before we move on to Ghislaine Maxwell. Yeah, people agree, painfully boring and long. Why so many sidebars? These lawyers are objecting a lot, and the judge does not want open discussion about what these objections are, although they've done it a lot. And I would be annoyed if I was the defense attorney. I would be like, Judge, can you tell them to stop making speaking objections? But the defense has done it too, because it's basically a lawyer telling the jury that this is BS when you object. It can go both ways. I mean, you can cut off their argument, but the jury can also think you're a jerk. New Chris, I wouldn't say that necessarily. I think that if you're elderly and you start a conflict and the person throws 2 or 3 things at you and then lunges at you, then potentially you can shoot him. But I agree with you. I don't think the elderly should go around starting fights and then shooting people. I'm with you. Interesting. So New Chris said, I bet my Bulls tickets. I would love to win your Bulls tickets. That if Reeves didn't have his gun in his pocket, he wouldn't have even said anything to Olson. Could be true. I agree. When he got shot, he would have dropped the phone. Thank you for noticing the lights. Rye Davis and Beverly. Yeah, just trying to have some fun. I don't think anybody really cares what it looks like. I think, this type of a channel is more about the content and the discussion than what it looks like, than being visually pleasing to the eye. But why not? I'd like to have some fun with that. I think I see some other YouTubers that are in different, realms than the legal realm. And, some stuff look cool. So I want to try it out. Thanks for noticing. So Sabrina, that's the big question. So is that true? Did the victim really throw his cell phone at the shooter's face, or is he just saying that now? That's what the jury has to decide. And did the state disprove that? That's the problem. Is if Miss Olson would have said, I was right there, there's no way he threw the cell phone, and that was her testimony, then they could have disproved that. But she didn't necessarily say that. Curtis Reeves wasn't even sure that he threw the cell phone. They're just kind of piecing things together, like something definitely hit me in the face. I had a red mark there, and the cell phone was at my feet, so it had to be the cell phone. And the state has the duty to disprove self-defense, so they really had the burden to try to give the jury something else to hold on to. I saw somebody talking about shoe reflection. Yeah, they talked about some stuff, but all those people in that theater, you've got the video. I would have really hammered home on that a little more, because I do think that that could be the linchpin here. Like, if you're throwing a cell phone at somebody's face, they say, and the way the law is written and the way all the medical experts in this case testified, that could cause serious bodily harm, and you can respond with deadly force if serious bodily harm is being inflicted on you or is about to. State did not do a great job, according to Lit. Jerry Johnson, why would you say you wouldn't be picked as a juror in this in a case like this? I am a criminal defense attorney. The prosecutor would strike me. I used to be a prosecutor, but that doesn't really matter. The fact that I'm practicing actively now, they would never pick me for this case. I actually wouldn't even make it into the jury pool. Somebody would cross my name off beforehand, whether it's the judge or one of the lawyers. More guilties coming through. Expat, is the phone a lethal weapon? It's not a lethal weapon, but it's a weapon that could cause great bodily harm, according to medical experts. Beverly Alford, I carry a gun allowed in theaters in my state unless otherwise posted. All folks in the media asking why would someone carry a gun in a theater must be not be fans of the Constitution. I mean, yeah, I don't think you have to carry a gun in a theater, and the theater can have signs posted. But even if you carry a gun with a sign posted, you're not breaking the law. They can just kick you out. They're a private entity. Cyrus, let's get to your super chat. I'm interested in your opinion about the international laws Ukraine is breaking. I am not up to speed on the international laws Ukraine is breaking. I know what's going on with the Russian invasion, but I'm not aware of the international laws Ukraine is breaking. So I apologize. I'm not able to answer that. All right. Awesome. Thank you. Real Red. Max Lupo, feels like this case would have been almost impossible to prosecute without the post-Miranda statement. I disagree. I think potentially the defendant could have come up with a better explanation of some things, but the video evidence was the most important piece. I think with that video, they were going to prosecute this every time. Rachel, yeah, we've talked about this a few times. I'll go quick here. I don't want to bore people that have already heard me explain this, but it's taken 8 years because both lawyers were okay with the delay. The defendant was on house arrest, not sitting in prison. We had the pandemic, obviously. We had the stand your ground hearing, which is basically a week-long trial, mini trial, bench trial. The defense lost, then they appealed it, and then they lost that appeal. And while all this was happening, the Florida Supreme Court was changing the stand your ground law. They shifted the burden from the defense, who had to prove that it was self-defense and the defendant should be immune, to now the state has to disprove that it was self-defense by clear and convincing evidence. And so once the Florida Supreme Court changed that law, these defense attorneys and the defendant wanted to see if it was going to be retroactive or not, meaning would they get a new hearing with this new burden? The Florida Supreme Court came down and said, no, this is only going to take effect in the cases that happen after we change the laws. This case happened prior to when we changed the law, so it will be ruled under the old law. And that was, a lot of that caused most of the delay. There was also an appeal with his bond issues. And so multiple appeals, stand your ground hearing and trial, and the change of the law really had a lot to do with, and the pandemic, the delay in this case. Thank you, Spiley. So Max Lupo, why not more pressure on the fact that Curtis initiated contact every time? I'm assuming the theater policy is that you contact manager, never engage directly. I don't know what the theater policy is, but there's been evidence that he didn't initiate contact every time. That when he came back in and initiating contact, that was also, he didn't contact the plaintiff or the victim ever. So initiating conversation, I think, could be fine. And I think saying, if I knew you would have turned your phone off, I wouldn't have, told the manager. Like, that's not initiating negative conflict. That's not creating conflict necessarily. So I'm not sure. No problem, Rachel. Happy to answer it. All right. So we've kind of gotten through the Curtis Reeves question. Now let's jump to Ghislaine Maxwell. And this is really interesting. So Scotty David, 35-year-old juror number 50, I believe, was on the jury and went to media outlets afterwards and talked about how his experience as a victim of sexual violence rang huge in the jury room, and he was able to convince some jurors that weren't sure to move toward convicting Ghislaine Maxwell. Okay, federal court case that she lost. She's Jeffrey Epstein's right-hand woman. So after that happened, obviously the defense attorneys go forward on a motion for new trial. They want to talk to this juror and another juror, and they ask the judge to hold a public inquiry because they believe he lied on the juror questionnaire and throughout jury selection. They didn't have the opportunity to question him, and they didn't have the opportunity to strike him, and they argue, and they are right, that if they would have known this and if he would have been honest in the jury questionnaire, he would have been struck for cause. They would not have even needed to use a peremptory challenge on him, and that is a major problem. And therefore, especially because he even admits that he had an effect on change, maybe he was a leader, like I talked about earlier, on changing the minds of other jurors, Ghislaine Maxwell needs a new trial. Well, Judge Nathan initially is denying their motion for new trial, and denying the opportunity to talk to the other juror, but she is granting their motion to speak to this juror. The judge is going to question this juror publicly in federal court to talk about why he answered the way he did on the jury questionnaire, why it was different, clearly different than what he told the media stations. Okay. What is very interesting and crazy about this and unprecedented is technology. We're able to see and hear what these jurors say on national media. And I want to find. Okay, so here's what I found. Screenshots of David's online activity, which is the juror, revealed in court papers. They showed that he tweeted at Annie Farmer, one of the 4 women who testified as a victim about being abused by Ghislaine Maxwell at trial. He messaged them. And he since deleted his Instagram, Twitter, Facebook, and LinkedIn accounts. And the message that he sent to this victim is, thanks for being brave enough to stand up and share your experience. Your story was critical in how we reached our verdict in that jury room. Thanks for sharing my story. I don't know if that was a typo that he said my story. Wrote David to Farmer. That is really something to me. This is our worst nightmare as a lawyer. That somebody lies and gets in the jury room and flips the jury and then goes out afterward and reaches out to the victims or witnesses on the other side. Now, I have had a lot of pushback on Instagram, on YouTube, everywhere that, Zor, we are going to answer that question, so stick around. That's the case I'm going through next. That people are saying it's so unfair that victims of sexual violence can't be on juries. That's absolutely not the case. They absolutely can be on juries. They probably will not end up on a jury where it's a sexual violence case similar to their case, because I'm not saying they're all biased. We just want to make sure that we have the most fair and impartial jury. So it's not even that lawyers strike them. A lot of times they get struck for cause because of how the laws are written in trying to get a fair and impartial jury. And a lot of people are upset about that, and I understand. But if you feel like you were wrongfully accused of something, robbery, murder, whatever it may be, would you want somebody who actually did experience that coming and deciding your fate? Maybe they don't think the person in their case got punished enough. Is that going to come into play? And our judicial system, especially our criminal judicial system, is not going to allow that for the protection of the criminal defendant. So you absolutely can be on juries. You'll probably be a great juror on a lot of cases, especially civil cases and other criminal cases that are not exactly the same as what you went through. So that is not the case. And we absolutely don't strike every juror that's been through something like that. Absolutely not. So I just wanted to clear that up when talking about Ghislaine Maxwell. Now, let's look at something here that I found. And it didn't take that much digging, but I just think it's interesting. And it's not that even that he had this history of sexual violence in the past. This is more of what it's about. This is his juror questionnaire. Question number 48. It's been made public, by the way, this jury questionnaire. Sorry for the video and the ads, but whatever. All right. Question number 48. Have you or a friend or family member ever been the victim of sexual harassment, sexual abuse, or sexual assault? This includes actual or attempted sexual assault or other unwanted sexual advance, including by a stranger, acquaintance, supervisor, teacher, or family member. Yes, self, which is what he should have checked according to his statements to the media. Yes, family or friend, or no. And he clearly checked no. So based on what he said to the media, the judge is saying you have given false information. Now, here are some other important things. 48A. If yes, without listing names, please explain, because we want to know, is this something similar? Is it different? Question 48B, if your answer to 48 was yes, do you believe that this would affect your ability to serve fairly and impartially as a juror in this case? He could have checked no to that, because obviously he thinks he still could have been fair and impartial, but he didn't even check either one of these. And if yes to 48B, meaning if you think you can be fair and impartial, please explain why. It is set out here in the jury questionnaire to avoid this problem specifically. So there it is in black and white. It's been made public. He was not honest on his jury questionnaire. Now, I think he said it was a mistake because he went through it quickly, which is fine. If it really was a mistake, they'll dig into that. They'll talk now whether or not he was fair and impartial, whether or not that made a difference. To me, she has to get a new trial. What do you guys think? Let me know in the chat. Write new trial or no new trial based on this. And has nothing to do with whether or not you feel like Ghislaine Maxwell is guilty or innocent, or not guilty, I should say. It's just whether or not you think this is enough to grant her a new trial. And I don't want to color you, but if it was you, how would you feel? And a juror did this to you. Do you think you would deserve a new trial? And I'm going to read a quote from the judge's order. To be clear, the potential impropriety is not that someone with a history of sexual abuse may have served on the jury. Rather, it is the potential failure to respond truthfully to questions during the jury selection process that asked for that material information so that any potential bias could be explored. And that's the key, the material information. This information is material, meaning important to this case. So had he told the truth, at least they could dig into it. At least they could ask him, could you still be fair and impartial? Let's talk about it. Let's talk about your experience, even if it's in private, up at sidebar. We have to clear the courtroom. We want to talk just to make sure you're going to be a fair and unbiased juror for this case. Ghislaine Maxwell did not get that. She did not get a fair and unbiased jury in this case, in my opinion, and that's why she needs a new trial to protect our system. So there is a slew of new trial votes in the chat. Even some new trial, unfortunately, Becca, that's fine if you feel that way, but you still want to protect the judicial system. Dirty Rick is asking me to do a poll, as if I know how to do that. I don't know how to do a poll, but I will learn by the next live because I should know how to do that, right? But yeah, a lot of new trials here, one or two, no new trials. All right. All right. Now, time for questions on Ghislaine Maxwell. I am going to scroll up and see if sure, give her the public inquiry. How's going to make a difference in what she did? Not necessarily what she did, just whether or not the trial was fair. That's all. I'm not pro Maxwell, but I believe she deserves a fair trial. Absolutely believe she deserves a fair trial. Leslie thinks he should pay all the court costs for lying. It is rough, man. A lot of wasted time, energy, and resources. All right, let's see. Space Cube, somebody asked me what's the best way to get out of serving jury duty today, literally. And I told them, nah, you got to go do it. Civic duty. Beverly Alford, do we know whether or not the other non-juror number 50 jurors shared with the judge that juror 50 tried to persuade them to convict Maxwell, or did juror 50's actions not come out until his interview? I believe it all just came out from his own TV interview. I don't think anybody else like ratted him out or anything like that. Or even probably thought to rat him out because they don't know how he answered on the jury questionnaire. So if you were there and I was there and we both had the same questionnaire, we saw that question, we figured he answered it appropriately, but they still put him on the jury. So you wouldn't know he did anything wrong if you were on that jury and he was convincing you for a guilty verdict. Candy says, I say her name properly. It took a long time. I've pronounced it all sorts of incorrect ways, so don't give me too much credit. Interesting, Connor. Connor thinks maybe a conspiracy theory. Yeah, New Chris, I see your Scott Peterson questions. I don't want to jump to random cases just yet. Max Lupo, if they do another trial for Ghislaine Maxwell, State definitely has the edge. Everyone deserves a fair trial. Okay. All right, so that's it on Ghislaine Maxwell. And now it is time to jump to the three officers, Lane, Kang, Tao, tried in federal court for the deprivation of civil rights, or not allowing George Floyd his civil rights, or providing life-saving measures on him like CPR. So we're going to talk about that case now. If you have questions about it, get in the comments and let me know. So I talked about this a little bit already on a video, why I personally probably would have voted not guilty on 2 out of 3 for Tao, who was on crowd control, and Lane. And then I would have voted guilty on Kang. I think it's really hard to not find Kang guilty. For sure, I would have voted guilty on Derek Chauvin in his cases. And I think somebody absolutely had to pay for what happened, how they acted, how long it was, how much they didn't care about what was happening to George Floyd, how they could have done a million different things. But I really am struggling with the Lane, the guilty verdict on Lane. Rookie cop who said, should we turn him over, who looked to see if his chest was moving up and down to see if he was breathing, looked to see the blood flow in his veins. And as soon as George Floyd was turned over, where he saw his face on the stretcher and knew that it was bad, jumped in, tried to do CPR, was helping, doing chest compressions with EMS. To me, this burden now on officers, if they do everything Lane did, basically they have to tackle their supervising officer, Derek Chauvin, put him in handcuffs and haul him away while they have this crowd surrounding them. George Floyd, dealing with arresting George Floyd, whether or not you think he was resisting, he definitely wasn't just, sitting in the squad car, making it easy on them. So there was a situation they had to deal with. So really all Lane could have done was shove Derek Chauvin off physically and taken over, and then potentially had a fight with Derek Chauvin right there in the middle of the street. I think doing nothing is wrong. And I think, getting on top of him like Kang did as well is wrong. And I understand why he's convicted. But man, I struggle with the Officer Lane conviction. So what I want in the chat now is guilty or not guilty for Lane specifically, because that's the one I struggle with the most. And this is the, for everybody saying, oh, guilty, 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 easy, guilty. This makes total sense. This crime charge makes sense for what they did. It is very unusual to see the federal government charge something like this. I think I read, and I've looked into it, I think this is the first time ever they have tried and convicted law enforcement officers under this statute. And that should tell you something. Now, there's a first for everything. I get it. But this is very, very uncommon. I see some votes for half guilty from Starr. That means not guilty because the federal government has a burden of beyond a reasonable doubt. So he's only half guilty. He's not guilty, legally speaking. So somebody asked in the chat, what kind of sentence are they looking at? Let's share this screen here. Deprivation of rights under color of law. This section makes it a crime for a person acting under color of law of any state, of any law to willfully deprive a person of a right or privilege protected by the Constitution or laws of the United States. Very, very, very vague. Very vague. Sorry, I just noticed I still had that comment up. So, for the purpose of Section 242, acts under color of law include acts not only done by federal, state, or local officials within their lawful authority, but also acts done beyond the bounds of that official's lawful authority. If the acts are done while the official is purporting to or pretending to act in the performance of his or her official duties. Persons acting under color of law within the meaning of this statute include police officers, prison guards, and other law enforcement officers, as well as judges, care providers in the public health facilities, and others who are acting as public officials. It is not necessarily that the crime be motivated by animus towards the race, color, religion, sex, handicap, family status, or national origin of the victim. And you can kind of catch there at the end that this usually is violating somebody's protected class. That's the constitutional protection usually they're talking about. And here is the potential punishment. The offense is punishable by a range of imprisonment up to a life term or the death penalty, depending upon the circumstances of the crime and the resulting injury, if any. So, maximum potential penalties for these officers for this conviction. That's what they're looking at. Yes, I see that the other two officers, I know the other two officers got more charges than Lane, but I mean, it doesn't matter. As you see, he gets convicted of that. He's looking at life in prison or death. So, I mean, I don't think those additional charges really matter that much to me. So mostly not guilty for Lane. There is a couple guilty votes in here, but mostly not guilty. Don't know enough details about Lane. I gave as many as I could give here based on what came out in the trial. Lane was the only one that helped try to get him help. Correct. All three guilty. I watched that video. Yep. Lane facing the maximum penalty. Yes, Zor, there are guidelines, and potentially we can go through and talk about what those are, but he's still, I mean, no cap is the point. There's no cap on what they're looking at. Let me scroll up here, see if we have any questions about this trial. Oh, a lot of people were asking, why did the federal case happen before the state case? I don't know, just timing sometimes when you get a trial date, when it happens. Chauvin's state case happened first, then the federal case, and this one, the federal case happened first, then the state case. They are being charged with accessory to murder in the state case. Now that they're convicted, potentially we could see some plea deals go down in the state case. Doesn't necessarily have to be that way, though, especially for Lane. If I was him, I would take it to trial. Yeah, Candy also asked that. Diana found being on a jury fascinating. I would do it again in a heartbeat. Most people that are on it actually enjoy the experience and have positive feedback about it. So Space Cube, why couldn't he have discreetly told him to get off? He discreetly told him asked, should we roll him on his side? I mean, obviously this jury felt like he should have done more. And then some people in the chat agree. What does that look like? Just continuously ask? I agree. I think he could have continuously said, you need to let him up. You need to let him up. You need to pull him on his side. You need to let him up. Are you sure he's breathing? He could have done more. I agree. I just don't know if it rose to the level of this criminal behavior. Yeah, Cordoba said there's a case in Florida where a police officer grabs a sergeant to get him off a suspect, so not an impossible thing. I agree. But is that the standard? Is that going to be the standard now for officers? Michelle, that's mostly the case. I mean, that's mostly the case. Yes, Beverly, he can appeal. Does Lane have recourse? Can he appeal? Why aren't these three in custody? They're under the same bond conditions before, so the court didn't feel like they were a risk to the community, a flight risk. So it's just kind of the same bond conditions. Zor saying the same thing about good experience on a jury and it felt good to do his part. I agree. All right. So I think that covers the three main cases I wanted to hit today. A lot going on this week. So now is the portion where you can get your questions into the chat and I will answer your questions. It's wide open Q&A, whatever you want to talk about. Again, I haven't watched every single case that's out there right now. I haven't reviewed every case in the past. But if I know what we're talking about, or if you have some details and some context to your question, I'll make sure to get to it. And I'll get to as many of the questions as I can in the chat before we sign off. We have at least 15 minutes here to talk about it, depending on how many questions there are, as usual. If you don't already subscribe to our page, please take a second and subscribe. We have a lot of fun here, especially on the lives on Friday when we go case by case and we answer a lot of questions. So make sure you subscribe and hit the bell so you know when that is. Sometimes it changes because of my schedules. If I'm out of town, if I'm in trial, I won't be able to do it at 4 o'clock. We'll have to do it at night. We post a couple videos every week breaking down a bunch of different cases going on. So make sure you subscribe to the page. If you haven't already, hit the like button on this video and get in the comments if you're watching this after the live and you have questions, because I'll get into the comments later and answer your questions. Cordoba, yeah, it was a cool video. And I think he may do some on some other politicians as well and some legal troubles they may be facing. Beverly, thank you for educating me. Go buy a beer. Thank you for being here. Thank you for being here. A lot of good comments and questions from you, so I appreciate it. It makes it fun. I mean, when we're talking about what you guys want to talk about, that's what makes it fun. That's what makes the content fun. That's what makes it a free-flowing conversation. That's how we can go case by case and go all over the place and just answer questions. I get questions about law school, about here. Oh, somebody asked, I don't know if it was you, Beverly, but somebody asked about, how close is Tampa to Pasco County? Very close. They touch, literally, Tampa and Pasco County. So basically, they're very close. It's basically, Hillsborough, Pinellas, and Pasco County are all kind of the Tampa Bay area. So they're all very close, because somebody was asking about how close the Curtis Reeves case was to Tampa. Ray Black, why are some never called for jury duty? It's pretty random. I know some people that are called all the time and some people that are not. Diana McGinnis, the questionnaire for Gulen said, if you ever had any unwanted sexual advances, surely that excludes almost all women. It does not exclude them. They just put it on there. If you check yes to that, and then you explain, in college, frat boys liked to hit on me at the club, that's fine. That's not going to strike you from this case. That's not going to make you a biased witness. That's the whole point of why there is the explanation questions after the initial question of, have you had those unwanted sexual advances? Maybe it happened at work and you quit your job. Maybe you had a a lawsuit for something like that at work. Again, that may not affect your ability to be impartial for this trial, but that's the whole point of why you have to answer truthfully, give explanations, let the lawyers do their job in voir dire and picking the jury. Arbery federal trial, I don't think there was any surprises there. They were convicted. R. Kelly new defense, I've seen a lot about this and people saying, you said he had no chance at appeal. I don't think he has no chance. I just think it's an uphill battle and it's difficult. I have not looked into what the new defense is, but I will, because that is a case that is very interesting to me. And R. Kelly, who, man, I really loved his music. Let's see here. Lisa Gooden, if you are a witness and a lawyer is screaming at you, is there any way to stop him or her? So the other lawyer should object to that as badgering. The judge should protect you from that. I do think sometimes maybe people in the chat think lawyers are screaming when they're actually not. I think a lot of times lawyers may get loud if the witness is being argumentative. So, you know, I definitely think you can ask the judge and say, Judge, can you stop screaming at me? And then you'll figure out whether you're doing anything wrong. Because if the judge just says, yes, absolutely, lawyer, stop screaming at her, then you weren't doing anything. But if the judge reprimands you and talks to you and the lawyer, maybe you could be playing a part. And I'm not saying you personally, but some of the witnesses. All right, let's see here. Spiley765, what do you think of the Crumley parents going to trial manslaughter charge? How can that work? I don't know what you mean by how can that work, but I think they should go to trial. Another unusual charge, another thing you don't see very often, and see if, you know, the state can prove it. It's an interesting charge. That case is interesting. We'll talk more about that in the future for sure. So Dash, Kang also a rookie, I agree, but you think he's guilty because he didn't say, should we roll him over? I don't think he tried to do really anything to try to protect George Floyd's civil rights, which is what the case was. And he was also on top holding him down. And I think there's a theory that, but for him also helping Derek Chauvin hold him down, maybe George Floyd wouldn't have died. So I think King is a little bit more responsible because of his physical actions and what he didn't do in the case. Feel free to disagree. People like to make fun of guests I have on the show, which is, you know, not cool and not interested. I don't care. And you can keep it moving. They like to make fun of my beard or something like that, or the way that I look or my hair. I think it's funny. That doesn't bother me. People like to talk about how I miss parts of trials. They like to hate how I interrupt videos that get played. And I'm like, if you want to just watch the video with no interruptions, this is not the channel for that probably. But I say all that to say disagreement is absolutely okay in the chat. We welcome it. We think it breeds discussion. I like diversity of thought and diversity of conversation. So feel free to disagree with me is why I was saying all that. Yeah, Rittenhouse wants to sue everybody who has an opinion. This will be really interesting to see how these lawsuits that Rittenhouse is saying he's suing Whoopi Goldberg and everybody. Have I ever been involved in a RICO case? Yes, I have. You're not going to like me. I feel like Lane will get off on the criminal charges because it's very different than the civil rights charges. I think she means the state charges versus the federal civil rights charges. And I think it's going to be harder to convict him under the state accessory to murder charges. I agree with you. Yeah, a lot of people saying they probably won't give him life. I agree. I don't think they'll get life, but the fact that they could is a little scary. Will you help Lane, Peter? I'll help anybody that calls me, but can't make any promises. Hello to everybody who just joined the chat. Michelle, I personally can't take a lawyer in a bow tie seriously. So I went to Florida State University, which is in Tallahassee, which is very southern, you know, in Georgia, a place like that where they wear bow ties all the time. And some lawyers and judges ripped them, made fun of them for it. Some loved it. It kind of depended on the person's thought. Yeah, New Chris, comment on Scott Peterson. I really don't. I have not researched it, so I'll have to look into it. I've seen some stuff, some headlines about that he might be getting a new trial, but I don't have enough really to comment to add any value to it. And on the show, I like to talk about things I feel like I can add value to, that I've experienced in and that I've read, and I can kind of break down from a different perspective. Unfortunately, I apologize. I do not have the info on that. Dash, good question here. Why is a judge allowed to be influenced by letters of support like Chu was for Potter? I wish I knew we could influence a verdict with mail. Not a verdict, but a sentence you can. And because it really is supposed, and this is how we want it to be, right? We want judges to take things into account, especially for leniency, if that exists about a person. Because one decision they make and one mistake they make, as horrible as it can be, does not change what they've done for their entire life. Now, it doesn't mean you just say they're not guilty or say they're innocent or don't punish them, but it can affect their punishment, which is why we have sentencing guidelines in a lot of situations. They are guidelines. Judges can depart from those guidelines. And it's not just Chu and it's not just Potter. This can happen in every case. And as in criminal defendant cases with sentencing hearings, we always provide letters of support and testimony of support that can affect the judge's ruling. This was not unusual. This happens in every single case where there's a sentence. Yes, Nadia, please do. We talked about Reeves. We talked about the George Floyd officers, and we talked about Ghislaine Maxwell. Do I believe the excited delirium theory? I think that the defense attorneys put on some good evidence that the police department used it in their instructions and training. Whether or not I agree with it, I don't know. I mean, I'm not a doctor, but I do believe that the police department trained their officers on how to handle it, which that to me that holds some weight to me. Thank you, Spiley. Oh, Zor, that is also a norm up there. The seersucker with the bow tie. That is the norm. Beverly was a professor at Ole Miss. Students loathed the bow tie. The dean and provost. Yeah, at Florida State, we had a dean that was famous for his bow ties. All right. So we are getting up to the 1 hour mark, which is usually where I like to call it. And I kind of got to the bottom, got most of the questions in. If I didn't get to your question, I apologize. I got to as many as you can see that I could get to. If you're watching the video later, please leave a comment. If you have questions, I'll be happy to get into it, answer all of the polls and questions that we asked throughout. And make sure you hit the like button if you haven't already and subscribe to our channel. Jump into our videos, get in the conversation. Let me know what you want to hear, because we really try to build our content about what you all want to hear and watch. People asking some questions about other countries. I usually don't comment on that because I don't know. I try not to comment on anything unless I know about it. But thank you so much, everybody, for joining. Thanks, everybody that commented and got in the chat. Thanks for the super chats. Thanks for the likes. It's been fun. We're going to keep it rolling. But for now, let's get to the weekend. Everybody enjoy your weekend. The last question is, would you ever comment on the Dan Markel case given you went to his school? I wasn't planning on it. We'll see how it goes, and I may or may not comment on that, but we'll see. All right, that's it. Thanks, everyone.